importance of legal considerations to protect your proprietary designs, trade secrets, and process data for discrete automotive manufacturing. We'll connect key legal concepts to the risk your team may face and help you identify the threat, act immediately, and stay ahead. The Computer Fraud and Abuse Act, Digital Millennium Copy Act, and Wire Fraud Statute provide federal prosecutors with a very effective arsenal to prosecute unauthorized access, intellectual property theft, and interference with production systems. Penalties can be in the form of fines, forfeiture, and jail time. Covered by criminal law. Negligence per se for inadequate safeguards, intrusion upon seclusion for unauthorized access to personal data, and product liability for harm due to insecure code are examples. High dollar value class actions in the wake of breaches demonstrate how civil lawsuits can result in penalties equal to or greater than criminal. Order and requires proof beyond a reasonable doubt. Tort law offers victims compensation under a preponderance standard. One involves the power of the state, the other private lawsuits, yet both can spring from the same violation. Double jeopardy for manufacturers. Methodological gathering, safeguarding, and analysis of digital data to piece together what happened. Forensic readiness allows you to quickly trace the path that design files took, leaving the network, identifying the guilty parties, and present courts or regulators with a defensible evidence. Each transfer, hash check, and storage environment of digital evidence, from the factory floor to the courtroom. Gaps in chain of evidence allow challenges from the defense and can make crucial CAD files or log records inadmissible, potentially jeopardizing your case. The Fourth Amendment limits government search. The Stored Communications and Wiretap Acts also limit grab-all monitoring. International transfers invoke GDPR. California's CCPA imposes separate consent obligations. Errors can destroy or invalidate evidence or result in fines. Cease and desist letters, regulatory inquiries, increased cyber insurance premiums. Criminal exposure arises when actions indicate intent, changing logs, declining audits, knowingly keeping stolen competitor data. Strong governance surfaces these red flags early. It's CFAA. Riley versus California increases privacy rights in device searches. Patent rulings like Comil versus Cisco on induced infringements clarify liability. Referencing these precedents bolsters your defense strategies. Ask yourself, do you know the rules? Can you put in place compliant controls? Will you build a culture that treats proprietary data as the crown jewel and legal risk as a board level metric? The future of your innovations depend on it. Thank you.